Good evening, ladies and gentlemen. Welcome to the Jewish Theological Seminary. My name is Rabbi Bert Visotsky. I am the Louis Stein Director of the Finkelstein Institute for Religious and Social Studies. We're here now in our 75th year at the Jewish Theological Seminary, which has been around now for 125 years. And we are delighted to have programs of public interest for the entire community. Tonight, we are hearing from Justice Stewart Rabner on eyewitness identification. His interlocutor and moderator will be Justice Shirley Kornreich. And now it is my pleasure to call up to the podium the Chancellor of the Jewish Theological Seminary, Professor Arnold Eisen.
Thank you. It's my pleasure also to welcome you to JTS. And my colleague, Bert Visotsky, neglected to mention the most important item. So this is the moment when we take out our cell phones and we silence them before the program begins. We all know that inevitably someone is not going to do this. The question is who it is, but let's hope that it happens as little as possible in the course of the program. And so we're not bothered by ringing. And if a cell phone goes off, I sure hope it's not mine. I want to say that JTS is delighted to sponsor a number of public programs bearing on general interest as it intersects with the traditions and foci of the Jewish Theological Seminary. We're very concerned with Jewish law at this institution. And anyone who's ever studied Jewish law, going back to its origins in the Torah, knows that witnessing, the identification of witnesses, who gets to count as a witness, how many witnesses you have, how witnesses are meant to be interrogated, all of this is a central preoccupation of Jewish law. It's something our students and our faculty talk about all the time. The issue that we're addressing tonight, with the help of Justice Rabner and Justice Kornreich, this issue is central to a lot of Jewish law. I want to take the prerogative of the microphone for 1 minute and recount a personal experience of how this issue came to be important to me. My wife and I had just arrived in Palo Alto. And after our first Yom Kippur, we are sponsoring a break fast. And we are waiting for a young friend of ours who was a medical resident at Stanford University and had served as chazan at the Yom Kippur service of the Hillel Foundation to arrive at our break fast. And he's late. And it's odd. And his mother is calling us from back in New York, wondering where her son is, and we have to tell her we don't know. Eventually, I get a call from the Palo Alto Police Department, and they're holding a man who has told them a story that he's on his way to our house for dinner, and the story is so strange, they want me to verify, in fact, who he is who he says he is, and they're holding him because there's been a peeping Tom in the neighborhood, and he perfectly fits the identification given by the woman who accuses someone of being a peeping Tom. And he has this very strange story. He has no ID on him. And he says he hasn't eaten in 25 hours. And he's wearing a suit and tie and bedroom slippers. And nothing he says makes sense. And I assured them he was who he said he was, and I told them about Yom Kippur, which at that point, this is before Silicon Valley booms, they didn't know about. I have to tell you that he so fit the identification given by the woman who was charging a person, they actually charged him. It took months and months and months to get the charges dropped and his record cleared. Partly the intervention was made by a good friend of ours, a leader in the Jewish community who was a professor of law and a professor of psychology and an expert in witness identification and how faulty it often is. We lived through this drama. This is not an abstract question of law for me. This is personal experience, which I learned from that Yom Kippur with one of our friends, and we tell it fondly every break fast when someone comes late to our break fast. We wonder if we're about to get another call from the Palo Alto Police Department. Having regaled you with that story, I now want to get on to the pleasant business of this evening. It's my honor to welcome you to the Bernard G. Segal Memorial Lecture established by JTS in honor of the late Bernard G. Segal, Bernie Segal, a philanthropist and community leader, Mr. Segal was the first Jewish president of the American Bar Association, the first Jewish chancellor of the Philadelphia Bar Association. In addition to his longtime career with the law firm of Schnatter, Harrison, Segal, and Lewis, Bernard Segal carried out special assignments for Presidents Eisenhower, Kennedy, Johnson, and Nixon, and worked tirelessly to extend the influence of the organized bar in matters of legal policy nationwide. He was recognized for his indefatigable efforts to expand and improve legal services for the poor, the powerless, and the dispossessed. Now, I have to tell you that as a student and graduate of Central High School, and as a student of the University of Pennsylvania, I've been hearing about Bernie Segal for a very long time. Happen to have been very close to the former president of Penn, Martin Meyerson, who kept telling me what a wonderful person Bernie Segal was and how I had to meet him. And I looked forward to that. Unfortunately, it never came to pass. But I know, not just from the little piece of paper in front of me, but for long personal acquaintance, that Mr. Segal served his alma mater, the University of Pennsylvania, with great distinction, the Jewish Publication Society, the Philadelphia Allied Jewish Appeal, and the Hebrew University, where the law library is named for him. In addition to this evening's annual lecture, his support for JTS, which awarded him an honorary Doctor of Laws degree in 1977, has been recognized through the naming of the Bernard G. Segal Seminar Room in our Kripke Tower. At this time, I'm also pleased to welcome Mr. Segal's grandson, Mr. Mark Cohen, who is joining us tonight, Mr. Bruce Rosenfield, a former law partner of Bernard Segal, and to thank him for helping organize the program this evening and bring it to fruition. Unfortunately, Mr. Ralph Snyder, a former law partner also of Bernard Segal, could not join us tonight, but wish him well and thank him for his role in sponsoring and making possible this lecture. We also wish to welcome Rabbi Richard Hammerman, Executive Director of Congregation Agudat Yisrael of Caldwell, New Jersey, which is Chief Justice Rabner's home congregation, and other members of the synagogue, I understand, are with us here this evening as well. We welcome you tonight. Finally, a program note that if you would like to pose a question for Chief Justice Rabner or Justice Kornreich, there will be a possibility of doing that. Many of you were given index cards on your way in. Those will be collected at the conclusion of Justice Rabner's remarks, when for about 20 minutes or so, he will engage in dialogue with Justice Kornreich, and then we'll turn the floor open to you. So it's now my honor to introduce the Honorable Shirley Werner Kornreich, who will introduce Chief Justice Rabner. Justice Kornreich is a member of the Supreme Court of New York County Commercial Division. Earlier in her illustrious career, she worked as an appellate attorney for the Legal Aid Society Criminal Defense Division in both Nassau County and New York County. She was also a trial lawyer with the Legal Aid Society Criminal Defense Division in New York County. Subsequently, she worked as principal law assistant to Justice Ira R. Globerman in Bronx Supreme Court Criminal Division. It's my honor to introduce Justice Kornreich, who will introduce Justice Rabner. Thank you.
First of all, I want to say that it's such a pleasure tonight to introduce Chief Justice Stewart Rabner of the New Jersey Supreme Court. Of course, my view of Justice Rabner is colored by the fact that I'm a judge and by the fact that I used to practice criminal law both as an appellate attorney and trial attorney. But because of this work, I can truly say that his opinion in Henderson, the subject of the talk tonight, is really groundbreaking. It's groundbreaking in the fact that it protects many criminal defendants, people who are accused of a crime, but it's also groundbreaking in the process that it used to reach the findings in that court, and their use of a special master to do something we lawyers call is a Frey-Dauber hearing, but to decide that expert testimony can be effective, is generally accepted, as we say in New York and in New Jersey in the scientific community, and the findings that identification testimony is not what we as laymen think it should be, and putting those findings into effect in jury instructions and by using that in in what we call a pretrial hearing to decide whether identification can come in at trial. It's really something that no other court, I don't believe, in this country has done, and certainly we in New York are far behind this. There are also, New Jersey has a lot of different procedures that we just don't use, but this has gone so far in protecting the people accused in this in New Jersey, and I think a lot of the courts in this country are looking to Justice Rabner and to the New Jersey opinions and Henderson and other opinions, and I believe will follow Henderson in the future. So let me tell you a little about Justice Rabner. Justice Rabner was sworn in as Chief Justice in New Jersey in June of 2007 after his nomination by Governor Corzine. He was confirmed by the Senate and began as the 8th Chief Justice to lead the New Jersey Supreme Court since 1947. That was its constitution. He was a graduate of Harvard Law School, a law clerk to U.S. District Court Judge Dickinson R. Debevoise, and then after that he became an assistant U.S. attorney in New Jersey. He was chief of the office's criminal division, and prior to that was first assistant U.S. attorney and chief of the terrorism unit. Governor Corzine, in January of 2006, named him as counsel to the governor, and in September 2006, he became the New Jersey Attorney General, and his nomination to the Supreme Court followed that. Chief Justice Rabner is a member of the Board of Directors of the Institute of Judicial Administration at New York University School of Law, my alma mater. He served as a member of the Board of Directors of the Conference of Chief Justices from 2010 to 2012, is past chair of the Holocaust Resource Center of the Jewish Federation of Clifton-Passaic, and is past president of Congregation Agudat Yisrael of West Essex in Caldwell, New Jersey. And again, it's my great pleasure to introduce Justice Rabner.
Thank you, Justice, for that very, very kind introduction. I want to thank JTS for sponsoring this evening's lecture, Columbia Law School for co-hosting it, and I appreciate your welcoming some members of my family so warmly here this evening. Chancellor, I hope you take this next comment in the spirit it's intended. You will honor me greatly by not inviting me for breakfast this coming year. Before I get into the talk, I wanted to ask by a show of hands, how many of you have taken courses in psychology? How many of you in constitutional law or the rules of evidence? How many of you have sat on a jury? Okay, everybody can breathe easily and relax. I'm not going to force you to answer any more questions. Certainly nothing as difficult as that, but I thought that would be important to get a basic feel for the room. I'm not going to ask the next question, and that is, how many of you are expert in the field of eyewitness identification, because I think I know the answer. All of us, of course, are expert at some level. We've watched enough television, we've seen enough movies to understand how important it is when a witness takes the stand, points the finger, and says, that's the person. And believe me, it's even more dramatic in a courtroom than it is in the media that we enjoy. But what perhaps is less well known is how memory operates. And it's no longer accepted that memory functions like a videotape recording, where something is etched in your mind or frozen in time, and all we need to do is ask a witness at a later point in time to, push the button, and out will come a perfect recitation of exactly what they saw when they witnessed an event. Instead, social scientists have demonstrated that there are a number of factors that can affect and distort memory. Tonight, I want to speak about some of those issues in the context of an opinion that the New Jersey Supreme Court issued a little over a year ago in the case that you've heard by the name of State versus Henderson. It addressed the subject of eyewitness identification evidence, and in a unanimous opinion, the court found that the legal framework for analyzing the reliability of eyewitness identification evidence that had been in place for decades needed to be revised. And it did so after reviewing a very extensive record of social science evidence, having heard experts and reviewed the literature, which in fact demonstrated that there are many variables, there are many factors that can dilute, that can affect the memories that a witness brings, that memory is indeed malleable and can lead to misidentifications. The opinion made two primary changes to New Jersey law that is in effect in courtrooms today. First, a change to the legal framework for examining the admissibility of eyewitness identification evidence. Judges deciding pretrial whether the eyewitness will be allowed to testify in front of the jury about what they saw. And it directs judges to consider a broader array of factors in making that decision. Second, the decision requires judges to provide enhanced jury charges that are tailored to the facts of a case in order to enable jurors to understand the evidence when it comes in. Let's talk now a little bit about how we got to that point, why we made that decision, and what lies ahead. A little bit of background first, because I appreciate that there are some people here who are expert on the issue of eyewitness identification evidence. Indeed, there are some Columbia law professors here who are renowned experts who could be giving this lecture, and there are some people who have less familiarity with the subject of eyewitness identification evidence. So let's cover some basic principles at the start. We're talking about a variety of procedures that police officers use, law enforcement officials use, in order to identify a suspect in a criminal investigation. They include a traditional lineup, where a witness is asked to look at the suspect, standing beside an array of lookalikes, fillers, and make a decision as to whether they can identify the suspect from that live lineup. Photo array is another means of identification which mimics the live lineup, with the exception that instead of real people, it uses photographs. And show-up identifications are when law enforcement officials ask a witness if they can identify a single person that they're shown, is that the person? Now, of paramount concern is that we have a system that enables us to identify the suspect who in fact committed the crime and not accuse wrongly an innocent individual. And that requires individual witnesses to search their memories and not just make relative guesses from among the photographs or the people that they are asked to take a look at. And that requires us to root out practices by law enforcement officials who can suggest who the witness should identify and manipulate memory in a way that can compromise a defendant's due process rights. Now, the case law has developed over a long number of years in both the federal and the state courts. Without turning this into a law school class, let's go over some basic points that you'll need as a backdrop to the opinion and the lecture as a whole. The seminal federal case was a United States Supreme Court decision issued in 1977 called Manson versus Brathwaite. It related to how judges are to evaluate the admissibility of eyewitness identification evidence. And New Jersey, like virtually every state in the nation, followed suit, adopted the federal test as its own. In New Jersey, it was in a case called State versus Madison. Manson asks trial court judges to make two determinations. First, was the identification process that the police used unduly suggestive? And second, if it was, is there a very substantial likelihood of irreparable misidentification? And to assess that second prong, the reliability prong, the Manson decision outlines 5 factors that judges should weigh. Number 1, the opportunity of the witness to view the criminal at the time of the crime. 2, the witness's degree of attention. 3, the accuracy of the witness's prior description. 4, the level of certainty that the witness demonstrated at the time of the confrontation. And finally, the time between the crime and the identification procedure or the confrontation. Those factors come from a case called Neal versus Biggers. You don't have to write them down on your cards. You don't have to memorize them. We'll come back to them, and I'll remind you of them as we go through. It's interesting to note that the court did not explain how it chose those 5 factors. It didn't cite to any scientific literature, to any scientific studies. It offered no basis for having chosen those 5 factors and simply directed trial judges to weigh them against the corrupting influence of suggestive identifications in order to decide whether the evidence should be admitted and presented to jurors. The court chose this balancing approach, which it said was designed to address 3 interests: reliability, deterrence, and the effect on the administration of justice. And the court identified an important assumption that underlies its test, and that is that jurors have the good sense to be able to reject, to identify and reject untrustworthy eyewitness testimony. And once again, that reflects the expertise that courts have historically attributed to jurors who come into the court system and serve and evaluate the questions that relate to eyewitness identification evidence. And with that in mind, let's compare the common sense that we bring into the courtroom with some of the findings by social science over the years about how memory can be affected. Consider two studies that were done by a social psychologist, Elizabeth Loftus, in the 1970s. In the first, researchers showed people a film clip of a car accident, and they then asked the question, how fast were the cars traveling? The answers differed depending on how the questions were phrased. Some were asked, how fast were the cars traveling when they smashed into one another? And that group estimated an average speed of more than 40 miles per hour. Another group was asked, how fast were the cars traveling when they contacted one another? And that group estimated an average speed of more than 31 miles per hour. Slight change in the way the question was posed led to a very substantial difference in the answer that the witnesses gave. Similar study was done of college students, and they too were shown a film of a car accident, and one group was asked to estimate how fast was the car going along the country road. Another group was asked how fast the car was going when it passed the barn. A week later, students were brought back and asked if they remembered seeing a barn in the film clip that they observed. 17% of the group that was asked the second question, how fast was the car going when it passed the barn, remembered seeing a barn. Only 3% of the other group, those asked how fast the car was going along the country road, recalled seeing a barn. And of course, as you can imagine, there was no barn in the clip that they had seen. What do we make of studies like that? Well, it appears that people's memories can be affected by the power of suggestion. And it raises questions about how cues by law enforcement officials might affect an identification, might affect the reliability of a witness's recollection. But in the 1970s, when the Supreme Court issued its decision in the Manson case, there were very few studies like that at all. If you were to search through psychology abstracts and look for the words identity and eyewitness, you would have come up with only 4 published studies. Compared to the last 30 years, when there are more than 2,000 published peer-reviewed studies on the subject of eyewitness evidence. And in the past decade or so, we've seen both the court system and the law enforcement community respond to the studies that are available to all. Let's start with a couple of examples from the case law in New Jersey that grappled with the issues regarding eyewitness identification evidence. First is a case from 1999 that came before the Supreme Court by the name of State versus Cromedy. In that case, the court examined numerous social science studies that revealed that a witness may have greater difficulty identifying a person of another race. This case involved a conviction for rape and robbery that the court vacated because no such instruction had been given, and the issue of cross-racial bias was front and center in the case. And the court also directed trial courts in the future to give that instruction about cross-racial bias in future cases. Years later, DNA tests were conducted, and they exonerated Mr. Cromedy. Years later, in a case called State versus Romero in 2007, the court returned to social science studies that spoke about the fallibility of eyewitness identification evidence. And the court recognized that the accuracy of a witness's recollection and description and the witness's level of confidence may bear no relation to one another at all. The court directed that juries be told that in the standard jury charge when it would be relevant at the close of a case before deliberations. Meanwhile, policymakers, law enforcement officials also had access to these studies, and they made some changes as well. A number of states adopted guidelines for local law enforcement generally to follow when they conducted eyewitness identification procedures. And I'm proud to say, as a resident of New Jersey, that New Jersey's law enforcement community led the nation. The Attorney General in 2001 issued a very comprehensive set of guidelines for local law enforcement to follow. And they include guidance on things like the minimum number of fillers or lookalikes that should be included in an array in a live lineup, about not having the primary investigator who could identify the suspect and might convey information about who that person was during the procedure, not allowing that person to conduct the identification procedure, about telling a witness in advance that they shouldn't feel an obligation to make an identification and that the suspect may not in fact be present in the lineup that they're about to see, as well as a number of other things. At the same time, though, courts considered and continue to analyze cases using the Manson-Madison framework, and that created a number of challenges. Let me give you one example from a case the court considered in 2008 called State versus Adams. It involved multiple robberies, a homicide, and of course eyewitness identification. Let me briefly touch on just a few of the facts for you. The crime took place in April of 2000, which was before the Attorney General guidelines went into effect. There was a pretrial hearing. The detective took the stand and explained what he did in conducting the identification procedure, and here's what he said. He said he brought 3 photos with him, one for each of 3 suspects, and he showed them to the victim and to 2 other witnesses to the crimes, the equivalent of a show-up identification. And he acknowledged this was a deviation from standard practice, that if he had more time, he would have done it differently. He showed another victim 15 to 20 photos, but admitted in his testimony that the pictures did not look enough like the suspect that they would have been able to pass muster if a judge looked at this array of photos. They were not alike enough. He also said that before displaying the photos to the witnesses, the detective told them that the people in the photos may in fact be responsible for the crimes. And then he threw out all but the 3 pictures that the witnesses identified as the suspects. Trial court found the procedures to be unduly suggestive, no surprise there. And then it went on and applied the 5 factors that we touched on a few moments ago. And after doing the relevant balancing test, allowed the evidence to go forward and be presented to the jury. The defendant appealed after being convicted. And both the Intermediate Appellate Court and the Supreme Court affirmed the conviction relying on existing precedent. And that was the right decision. It was the correct outcome to the case based on the law at the time and based on the fact that appellate courts rely heavily on the testimony in the record and the findings of the trial court judge. They're not sitting and listening to the witness and making a different credibility determination. So notwithstanding the obvious deficiencies in what happened, the court affirmed the convictions, and that certainly didn't deter the officer in terms of correcting the conduct that the officer had engaged in carrying out the identification process. In Adams, as it happened 2 years before in a case called State versus Herrera, the defendants urged the Supreme Court to abandon the standard for admissibility that had been in existence for decades and to fashion a new standard relying on New Jersey's Constitution. They asked that we do so in light of what was then known about social science evidence on eyewitness identification. The court declined the invitation, as it had done 2 years before, and encouraged the parties to go back and develop a record, to present the evidence in a way that it could be assessed, that it could be tested, and that could be then relied upon by the court. The Henderson case is the next link in that chain. The case involved a murder that took place in the year 2003 and an identification a couple of weeks later by a witness to the crime. And the court granted certification. It agreed to hear the case in 2008 and invited the Innocence Project and the Association of Criminal Defense Attorneys to participate as friends of the court in the process as well. And in the written arguments and in the arguments they made in open court to the justices, counsel raised questions about the shortcomings of the Manson-Madison test, relying on current social science evidence. But once again, we didn't have a record to test the arguments that they were presenting by just simply citing to law review and social science articles. What did the court do? As Justice Kornreich alluded to earlier, we appointed a special master and asked that he develop that record. And that was an approach that the court had taken in a number of similar situations where the court concluded that a better understanding of the science was vital to a fair and accurate evaluation of the test that was being presented to us. In 2004, the court was asked to review a 25-year-old ruling about whether hypnotically refreshed testimony could be admitted in court proceedings based on new scientific evidence about its reliability. Years later, science raised questions about the Alcotest machine in New Jersey. If you ever pulled over and have had a little much to drink, you'll have a better understanding what the test is about. It's the breathalyzer test. And there were some scientific issues that have been raised about its reliability. And in both cases, the court sent it back for a hearing and asked that judges assess the existing test, the existing machine, in light of new science, which is what happened here. And those hearings involved expert testimony and scientific literature that was reviewed as well. So against that backdrop, we appointed a retired appellate division judge by the name of Jeffrey Galkin and gave him that assignment of developing a record, taking a look at the scientific evidence in order to assess whether the Manson-Madison test retained its viability and whether those 5 factors still make sense in light of what had developed since 1977. And over the course of 10 days, the Office of the Attorney General, the Public Defender, the 2 friends of the court that were involved in the case called 7 expert witnesses who testified over the course of 10 days, presented more than 200 social science studies that had been subjected to peer review and published, and more than 360 exhibits overall. What did the hearing reveal? First, it confirmed that misidentifications are the leading cause of wrongful convictions nationwide. The Innocence Project has reported that about 75% of convictions that are overturned as a result of DNA evidence involved misidentifications. And studies from actual police case files, as well as field experiments, bolster that statistic. There were 4 studies done in Sacramento, California, and in London, England, that produced data from thousands of actual eyewitness identifications. And they revealed that about 1/3 of eyewitnesses who made identifications in those police investigations selected innocent fillers, people the police knew could not have committed the crime. And field experiments of about 500 identifications reached much the same results. Second, the record revealed the extent to which memory is malleable, how system variables, these are variables within the control of law enforcement, like how the identification process, how the lineup is conducted, and estimator variables, those outside the control of law enforcement officials, like lighting or distance or race or stress, can influence memory and can increase the risk of misidentifications. There are dozens of pages in the Henderson decision that go through the studies, that go through the findings. If you're having a sleepless night, get up on the internet, find the decision, you can read it. It'll be good reading then, perhaps only then. I'm not going to try to squeeze in all these pages in the next few minutes, but let's just cover a little bit of some of the hearing so that you can have a flavor for some of the science. Let's start with system variables, factors that are within the control of law enforcement. First area relates to something that's referred to as blind administration. The concept, in a nutshell, is that if the person administering the identification knows who the suspect is, that person, that administrator, can increase the likelihood of misidentifications by conveying information, even if they do so subtly or unintentionally, that can affect the witness's recollection. Scientists refer to this as the expectancy effect, the tendency to get expected results by shaping the response. There was a meta-analysis. It's a fancy word for an analysis that is conducted and combines data from across a whole number of studies. In this case, some 345 studies that concluded the overall probability that there's no such thing as an expectancy effect is near zero. That led to the relatively uncontroversial finding that to avoid feedback, the person administering the test shouldn't know who the suspect is, and that's something that can be accomplished with a small law enforcement department, with one that has limited resources as well. Another area related to pre-identification instructions. There's a broad consensus that the police should instruct witnesses before asking them to make an identification, that they shouldn't feel compelled to do so, to select someone, and that the suspect may not be among the array the lineup that is shown to them. In one experiment, when witnesses were not given those two cautionary instructions ahead of time, they chose innocent fillers from lineups that did not include suspects at a rate 45% greater than those witnesses who had been given the instruction. Confirmatory feedback was also looked at. That's something as simple as a police officer turning to a witness after the process is completed and saying, "You did a good job." That can have two effects, the studies show. It can artificially inflate the witness's confidence, and it can lead the witness to overstate the quality of their view of the events at the time that they took place. And hold that thought in mind when we come back to those 5 factors a little bit later on. Many other areas we're taking a look at as well, but let's move on to estimator variables, the variables that are within the control, outside of the control of law enforcement officials. One of the estimator variables involved related to studies that were done on weapon focus. And they found that when a weapon is involved during a crime and it is visible, it can distract a witness. It can draw the witness's attention away from the perpetrator if the crime is of short duration. In one study, witnesses were in a room with an individual whom they were later asked to identify. One group was with a person who was holding a syringe in a way that was physically threatening to them. Another group watched the same person holding a pen this time. They were all later asked if they could identify the person that they had spent time alone with, one-on-one. And they were shown a batch of photos that did not include that individual. 64% of witnesses from the first group, those who were with the person that was holding a syringe in a manner that was threatening, wrongly identified someone from the array that was presented to them. About half, only 33% of the group that spent time with the individual holding a pen, wrongly selected someone. Let's talk about the effect that stress can have on memory. How often have you heard a witness, most of the time in popular culture, say, "I will never forget that face. I've never been held up at knife point. I've never been held up at gunpoint. I will always remember what that person looks like." Let's take a look at some of the evidence that was presented during the course of the hearing from the social science. There was a meta-analysis done of 63 studies, which found that high levels of stress can affect the accuracy of an eyewitness identification. One example was a study that was done of 500 active military personnel, and they had an average of 4 years of active service in the military at the time they participated in this study. They were actually at a survival school training exercise. They'd gone through 12 hours of solitary confinement, and then they were subjected to one of 2 different types of interrogations. One group underwent a high-stress interrogation that involved actual physical confrontation. The other group, a low-stress interrogation with no physical confrontation. Both sets of questioning lasted 40 minutes, one-on-one. And days later, the service members were brought back, were shown lineups, and they were asked if they could identify the person that they had spent 40 minutes together with. Across the board, the people who participated in the high-stress interrogation did far worse in their ability to recall that individual accurately. Only 30% of that group, the ones subjected to the high-stress interrogation, were able to correctly identify their questioner. More than double that, 62% of those who had participated in the low-stress interrogation were able to make a correct identification. The hearing delved into other areas as well, with findings that you won't find particularly surprising, like the length of the encounter, distance, lighting, the use of a disguise, how much time had passed before the identification, whether the individual was under the influence of intoxication, can all affect the accuracy of a witness's recollection later on. So with those findings in mind, we took a look at what jurors intuitively understand. There was a study done of jurors in 2006, actual jurors in Tennessee, who were asked about their views on a number of the subjects that we've just touched upon. Fewer than half of them agreed with some of the basic concepts, like the importance of giving pre-lineup instructions. the effect of cross-racial bias, findings about accuracy and confidence and their relationship to one another. What do you think was the most powerful predictor of jury verdicts across the board? The confidence that a witness displayed when they testified on the stand, which science has shown can be affected by suggestive procedures, by feedback. And traditional cross-examination that we're used to seeing in court, on TV, can't really get at that, because eyewitnesses who take the stand tend to genuinely, earnestly, honestly believe that they've selected the right person. So the kind of cross-examination that would delve into a person's bias or their desire to deceive jurors for one reason or another will not really get at the complex issues about eyewitness identification that might be successful in other areas. After reviewing the evidence in the record, the court found that the social science evidence itself was reliable, was generally accepted by the scientific community, and following the usual framework for assessing scientific evidence, determined that it could be relied on for what followed. And where did that lead the court? To the conclusion, in short, that the Manson-Madison balancing test did not live up to its aims relating to reliability, to deterrence, to the administration of justice, and that is so for a number of reasons. First, under the old test, courts don't consider estimator variables, stress, weapon focus, lighting, and so on, unless, even though they can and do affect reliability, they're not considered unless the police procedure was unduly suggestive, and if not, they're virtually ignored by the judge in evaluating what to do. Second, and this is critical, 3 of those 5 factors that we talked about at the outset: the witness's opportunity to view the crime, the degree of attention that the witness reports, the degree of confidence that the witness displays, can themselves be unreliable when the police use suggestive identification procedures. And that's the irony of the existing federal test and the test that is now in use throughout most of the United States, that the more suggestive the behavior by police, the greater level of confidence a witness may report, the better their ability to have viewed the events they will report. So rather than deter suggestive behavior, the opposite may be happening. Third, judges only have 2 options under Manson-Madison: to admit the evidence or to suppress it. And given the complexity of the issues, that was an inadequate array of options we determined. So what did the court do? Well, I mentioned earlier, we made 2 principal changes to the law. And the first modified the nature of pretrial hearings, when judges evaluate what happened during the identification process, and all that's needed in order to get a hearing on that in New Jersey is for a defendant to come forward and present some evidence of suggestiveness. They get a hearing. For the most part, the suggestive conduct has to be tied to something that a law enforcement officer did. But once that showing is made, the judge can consider and the parties can assess and probe all of the system and estimator variables that are relevant in the case that may demonstrate some unreliability. Henderson lists multiple factors, more than a dozen factors, for judges to consider, to put into the balancing that they do in making a decision about whether the jury will then hear the evidence. And they're based on the science. The second critical difference is a focus on enhanced jury charges. We recognize that in most cases, witnesses are going to be able to testify and present their evidence to the jury. That's because the threshold for suppression, for keeping the evidence out, remains very high. The defendant has to come forward and demonstrate a very substantial likelihood of irreparable misidentification. So to help juries evaluate that evidence, which may well be more complex than juries appreciate when they take their oath as jurors, to help them better be able to assess that evidence, we've directed trial judges to give charges that are tailored to the facts of the case and are based on the science. 2 committees drafted proposed charges. They were made public for comment by lawyers and advocacy groups. The court modified them, put them into effect, and they're now in use in New Jersey since last September. Now, in drafting the model charge, we tried to do a couple of things. We tried to use neutral language and language that was supported by generally accepted scientific principles in order to educate jurors and help them in their important task. And I think an important benefit as well from these charges is that we won't have dueling experts come in and present their understanding of what the science of eyewitness identification is all about. Let me give you two examples. If you were sitting in a trial in New Jersey tomorrow and it involved weapon focus and you got to the end of the case, this is what the judge would tell you. You should consider whether the witness saw a weapon during the incident and the duration of the crime. The presence of a weapon can distract the witness and take the witness's attention away from the perpetrator's face. As a result, the presence of a visible weapon may reduce the reliability of a later identification if the crime is of a short duration. In considering this factor, take into account the duration of the crime, because the longer the event, the more time the witness may have to adapt to the presence of the weapon and focus on other details. Just one other example. If the issue of how the lineup was composed is in question, a suspect shouldn't stand out from other members of the lineup, the judge would tell the jury. The reason is simple. An array of lookalikes forces witnesses to examine their memory. In addition, a biased lineup can inflate a witness's confidence in the identification because the selection process seemed so easy to the witness. It's, of course, for you to determine whether the composition of the lineup had any effect on the reliability of the identification. Again, if you're having a sleepless night, you can access all of the charges. You can take a look at the new court rule and read it for yourself and see whether it makes sense to you as potential jurors in cases. A number of states are looking at this issue. A number of them are looking at their jury charges on the subject. The Supreme Court in Oregon, not too long ago, issued an opinion that has a number of similarities to the Henderson case. It relied not on the constitutional due process clause, but on state rules of evidence and in making the findings that it did about eyewitness identification evidence. And the Supreme Court, a year ago, last January, also issued an opinion on eyewitness identification evidence in a case called Perry versus New Hampshire. There's not time to discuss it, and I wouldn't get into too much detail in any event, other than to tell you that it dealt with a different issue than the one that we're discussing this evening. It involved whether the due process clause is invoked when there's a suggestive identification process, but the police didn't arrange that process. In the case, a woman looked outside her kitchen window onto the parking lot and saw the suspect standing alone next to a police officer. It was suggestive, but the police didn't set it up and didn't ask her to go and look out the window. Majority of the court held that the due process clause was not implicated. Justice Sotomayor dissented and would have gone the other way. For those of you who have not yet mastered constitutional law, I'll sum it up in one sentence. Perry didn't address the continued vitality of the Manson test because the issue wasn't in front of the court. But I believe the issue will surface in another case, another day, because it matters a great deal. We continue to wrestle with the question of eyewitness identification in the 21st century because of the vital role that evidence plays in our system of justice. It's a routine part of so many criminal cases. It bears directly on guilt or innocent, and that means that what is at stake is the very integrity of our criminal justice system and our ability to conduct fair trials. We also shouldn't lose sight of the fact that everyone involved in the process has the same goal in mind. The defendant, the victim, the investigator, the judge, the prosecutor, the defense attorney, all want to make sure that the right person is identified and that the identification is put to a fair test. And that, I believe, is consistent with the core purpose of our criminal justice system, which the Supreme Court summarized succinctly 75 years ago in a case called Berger versus United States, when it said that guilt shall not escape, nor innocence suffer. I hope that the Henderson decision helps contribute to that aim, and I thank you very much for the opportunity to speak with you about that case this evening. Thank you.
I guess it's our show now. Chief Justice, your background encompasses time spent prosecuting crime, including terrorism. Has your view of identification evidence changed during your legal career? And if so, how has that evolution taken place over the time and over your different employment?
I was a prosecutor, federal prosecutor, for 19 years, and I handled a number of cases that involved eyewitness identification evidence, bank robberies, racketeering cases involving street crime type fact patterns. And I look back in time on some of the things that I said to witnesses, and I'm grateful that I never suggested to a witness whom they should identify. But when you meet with a witness who is nervous, who's about to stand or sit front and center in a courtroom, and they're having a hard time remembering the facts because of how anxious they are, I would say to them, take your time, breathe deeply, relax. You'll see how much will come back. If you just think hard, you'll be surprised at how much you're able to recall. Then, of course, you read some of these studies which plainly demonstrate that memory decays over time. It never gets better. The process is irreversible. And I do smile at some of what I said, but fortunately none of it led to an incorrect identification, because that's not leading you in a different direction. That's just encouraging a witness to remember things. But there's a difference that you'll appreciate as a state court trial judge between the state and the federal system, and that is federal cases, by and large, involve fair amounts of corroboration, where there's physical evidence or other proofs, white-collar cases, where you're not relying simply on a single witness and what that person remembers. But a rape case in state court, a robbery case, a homicide, attempted homicide, you will often have, as a state court prosecutor, somebody who says, I'm positive this is the person, and there's no other evidence to corroborate it. Those are the hard cases. We saw them on occasion in the federal system. There was a case I remember. I didn't prosecute, but I was keenly aware of it, as was everyone in my office, where a rape suspect was prosecuted because the rape had been committed on Fort Dix, a federal installation. The person was convicted. DNA evidence later exonerated that individual. So I think that the law enforcement community is very well aware of the issue, and it is certainly one that has more sharply focused me over the years.
Oh, I'm sure. I mean, as a defense attorney, I know that the cases that ever really raised issues for most defense attorneys are the ones that are identification cases. And those are always the horror stories. And I just was wondering, how many, so you didn't have a lot of identification cases in federal court, unlike state court.
True.
Which makes a huge difference. How did you become aware of these identification issues then?
Back then? Prepping witnesses. That one experience, as I said, was certainly an eye-opener for all of us. But the Department of Justice, actually, the New Jersey guidelines that I mentioned, that came from the Department of Justice, which I think was a little bit ahead of the curve in sensitizing its prosecutors to the issue. And it is gradually permeating the nation, and hopefully
Not New York,
improving.
Unfortunately. Not New York State. But anyway, the next question I have is, we, as lawyers, have heard Blackstone's adage many times, and often it's not attributed to Blackstone, but better that 10 guilty persons escape than that one innocent suffered. And that's the adage. Clearly, this is a concept that's integral to our system in the United States, probably the common law, where an accused is presumed innocent until proven guilty. We've heard this so many times. In fact, it's a concept which anybody who studied the Bible has also seen, where Abraham prays to God when he's asking for mercy for Sodom and Gomorrah, because there may be innocents present, and he's hoping that he can find enough innocents so God will save Sodom and Gomorrah. However, we're dealing now in times of very high crime, in times where there's a lot of terrorism, where really society has to be protected. And the public, and perhaps a lot of judges and prosecutors, are not exactly amenable the whole notion of letting one innocent go, even though there may well be, letting 10 guilty persons go, even though one innocent may suffer. So my question after that very long introduction is, how does Henderson fit into this dichotomy? And did you have a public reaction to Henderson? Did you get letters? Did people react given all of this?
I think Henderson fits in well, and I'll tell you why before getting to the public reaction. The case that I mentioned, Berger versus United States, the Fuller quote, and I love this quote. I had it on my wall for most of the time that I served as an assistant U.S. attorney, talks about the role of the prosecutor, the role of the sovereign in our criminal justice system. And it describes it as not winning cases, but doing justice. And it's very important. And it says, prosecutors can fight hard, they can land strong blows, but they have to be fair blows. And that goes to the tension itself of making sure that you're not doing things in an underhanded way, which my colleagues and I took seriously. You can see some of that tension in the opinion itself. One of the parties, the defendant, came forward and said, the court should issue a bright line rule that anytime the police officers make a mistake and deviate from the guidelines, the testimony should be tossed, should not be admitted, regardless of how serious a mistake, regardless of how many other indicators show that the identification evidence would have been reliable. And the court rejected that bright line approach.
So that would mean if it was, and it's always struck me as very funny, unduly suggestive. Instead of just saying suggestive, they say unduly suggestive. I never quite understood that. But so this would mean that if the ID was unduly suggestive, it should just be tossed aside.
Well, the argument that was made that didn't carry the day was that if they deviated from any of the guidelines, so for example, if instead of having 6 photos in the array or 6 people in the lineup, there were only 4, that's a deviation, the evidence should be deemed too unreliable and not admissible. And the court didn't go that way. It said we're going to do a case-by-case balancing to assess all of the factors that could demonstrate reliability in some other area, even though there was this mistake. And we weren't going to say that any time the constable blundered, that was the end of the case. And I think that did show respect for law enforcement's need to protect public safety and the importance the court system attaches to protecting the rights of defendants. The reaction, there were 2 audiences, if you will. One was the law enforcement community and the legal community, and I think that was pretty respectful of the opinion. Nobody viewed it as pro or anti-prosecution or defense. I think it was viewed as an attempt to wrestle with a serious problem. The other reaction, because the case got some attention publicly, were the letters that I received, and I got a good amount of letters from prisoners, from inmates who were serving their sentences, and a good amount of letters from clergy. And the largest group, believe it or not, were rabbis. And I'm not suggesting there's any connection between the inmates and the rabbis. The inmates, their letters all kind of followed a similar pattern. You, the justices of the New Jersey Supreme Court, are so wise, you understand the issue, now please set me free. And the answer was, it's a little bit more complicated than that.
Did you really answer all of them?
No. I did answer the rabbis. I did not answer inmates who had pending cases. The rabbis and clergy talked about social justice and the importance of the decision, and what I appreciated is more than half of the rabbis made note of the fact that the opinion was released late in August, shortly before the Torah portion, Parshat Shoftim, which many of you are more familiar with than I, speaks about the number of witnesses that you need in a capital case, and that one witness is not enough. And they reached the conclusion that it couldn't have been a coincidence that the opinion came out right before that Parsha. So if you look, we don't explain why we release opinions when we do. If you look at the opinion and look at the dates, there's a companion opinion. We only had 5 judges voting on it. One of them was days away from stepping down in the court. That would have meant we'd only have 4, which wasn't a quorum. We would have had to start all over again. You could draw a different conclusion about why it was released when it was, but who wants to argue with rabbis that we're taught to revere? So I never disabused anyone of that notion.
I just want to interrupt for 1 second because I know you have more dialogue. I want to ask one question, which was whether any of the rabbis who wrote you asked whether you would set them free. But I know also that many people in the audience, you have your index cards. Now is the time to write your questions. And you will see in a moment that our ushers will be going up and down the center aisles to collect them, and they'll bring them to me, I'll vet them, and I'll hand them on to Judge Kornreich. So I'm going to invite you two to continue your absolutely fascinating dialogue for a few more minutes, and then we'll get to audience questions.
I just wanted to ask, did you get any negative letters?
No.
Very interesting.
No.
That's great.
Maybe they didn't want to write if they had negative feelings. I don't know.
Okay. Henderson was a unanimous opinion, which is major. It's a very powerful statement. Did the tension between those on the court who felt it important to protect society, and I'm going back to that same theme, and the long-held concept of protecting the innocent create any difficulty in reaching unanimity, or was everybody on the same page when dealing with this?
Well, without breaching confidentiality, I'll tell you where we started. If you were to take the time to read the record and read the eyewitness, the expert testimony, and the studies, and this is a serious undertaking. It's not something you do lightly when you're late at night. It's hard to walk away from that without appreciating that there's a real problem. And all of us, the 6 justices who voted on the case, appreciated that. And our starting point as a result wasn't, is there something here that needs to be addressed? It was, what should the remedy be? Mm-hmm. And we appreciated that we were about to reverse course on a decision that the Supreme Court has had in place for more than 30 years, that every state pretty much has had in place. Mm-hmm. We knew that it would get some attention, and we understood the importance of unanimity. So respecting one another's views, mm-hmm. those on the right, those on the left, in a principled way, we were able to compromise and reach a unanimous decision, which we tried to do, and I tried.
What I was really taken with, and something I mentioned at the beginning, was that the process used. And yes, often an appellate court will send it back to a lower court to do something, the type of hearing you did, to see if there's junk science. We call it junk science, rather than good science that creates these issues of whether or not ID testimony is solid, whether it's reliable. But instead of sending it back to the lower court, instead you appointed a special master. And what brought that decision about?
I think the trial court judge wasn't available, may have retired. I forget exactly what it was. And we had high regard. This was a master who was truly special, very gifted appellate judge that we selected because the issue had come up so many times, and we had some appreciation for its complexity. So we were pleased that we had friends of the court helping out, and we wanted a good person overseeing this process.
That's interesting. It happens. It happens sometimes in federal court. There have been special masters that have done that, and rarely. I don't know of any time in New York. Maybe. I can't think of one.
Well, I'll tell you this if I could, and this was also part of our thinking. This is part of the public record now. All the testimony is out there. It is available. You don't need to hear this to determine whether the expert's being credible. You can assess it by reading it, and other courts may do so. And the scientific studies that we relied upon are also published studies. So this was a record that assisted, obviously, us in making our decision, but can be used by others.
And I must suggest it saved you time. You didn't have to go over a lower court's decision and either affirm it or not. That might have been easy, too. We've heard about misidentifications and what causes it through what Justice Rabner just said. And what I'm going to do next is what you've described to me as a bit of a law school test. I'm going to read from a case description that I got from the website of the Innocence Project. And as you told everybody earlier, on the website, it states that 75% of the people convicted and then eventually found to be innocent through their DNA were misidentified. And that's how they wound up in jail or prison, really. So this is a case study. It's a case study that's on the website, and it's about one such person who was misidentified. His name was Larry Fuller. He spent nearly 20 years in prison for aggravated rape. And it describes how he landed in prison, really. And these are the facts. In April 1981, a woman woke up at 6 a.m. to find a man with a knife on her bed. It was 45 minutes before sunrise on a foggy day, and the only light in the room, other than any light from outside before dawn, came from a digital alarm clock. She tried to grab the knife away from the assailant, but he cut her on the hand, the neck, and the back, and then he raped her. He got up and asked the victim if she had any money, and when she said no, he fled. The entire incident lasted only a matter of minutes. The victim initially told police that she could not provide a description of the perpetrator because of the limited lighting. However, 2 days after the rape, police showed the victim 6 photos at her home. Fuller's photo was among the 6 she was shown. The victim said that, quote, he looks a lot like the guy, unquote, but could not positively identify him. The investigating police officer issued a report recommending that the investigation be suspended, noting that the victim was unsure of the suspect at the time. The investigation, however, continued, and police remained focused on Fuller. A police officer went to Fuller's house and took 3 Polaroid photographs of him so that the victim could see a recent photo of Fuller. He then went to the victim's home to show her a second photo array. Fuller's photo was the only one that was repeated in the second photo array. The Polaroid taken exactly 1 week after the attack showed Fuller with a heavy, distinct beard. The victim became alarmed that Fuller had a full beard, since she had said her attacker did not have facial hair. Placing her fingers over the bottom part of the photo to block half of Fuller's face, she then positively identified him, and he was arrested in August 1981. Fuller had a 2-day trial in which the prosecution said the victim, quote, never wavered in identifying him. After deliberating for 35 minutes, he was convicted. Now, my question to you, and this is the law school part of this question, is what was wrong with the process in this case, and what would a New Jersey judge have done? And here,
okay.
I think I gave you a copy of the facts, so it's
did,
not a memory test.
I thanked you for that, and I wrote down some as you were just going through them again. Let me answer it this way in the form of a hypothetical rather than opine about another case. I assume it's all over and done with, but just in case it's not, I'll be on the safe side. But I'll be on the safe side, and if these facts came to us hypothetically today in New Jersey, here's what I think would happen. Here's what should happen. First, I'd want to know more. And there'd be discovery before the actual first court hearing, because you have 1 photo spread, you have a second photo spread, there's something funky going on with 3 Polaroid photos that I don't understand how they were used, and if they were shown, if the police officer walked in and said, is this the guy, and showed 3 pictures of the same person, that would raise serious red flags. So you'd want to know more about the process. You'd certainly get a hearing. You'd get a pretrial hearing. The witness, the defendant would come in and say, this was a suggestive procedure, if only because the same person appeared in both photos, and that reflects a concept referred to as mugshot exposure or mugshot commitment, where seeing the person a second time reinforces your first identification, right or wrong. But at the hearing, it's chock full of factors that we looked at: the use of a knife, the inadequate lighting, the brevity, the fact that there was no prior identification, and then there was an inadequate identification, if you will. That would all play into the judge's determination about whether the jury could hear it. I think what would be most important is what happened with those 3 Polaroids. Did they stay in a folder, or did they come out? And if they came out, then that evidence might not actually ever get to a jury. But since we're answering a law school question, you've got to answer all the facts. So let's assume it goes to the jury. The next step is going to be the jury charges. And you're going to be entitled to get charges by the judge about the effect of having seen the same photo twice, mugshot exposure, about the lighting, about the weapon focus, and so on. So no one can predict the outcome. The jury would make its determination at the end, but I'm sure of this. There would be enough red flags raised that this idea would be tested with care, and it would be scrutinized by the jury with care because they'd know to look out for some of the problems in the case if it came up today.
And part of the way they'd be looking at it is through the instructions. And at the end of every trial, there are always instructions that the judge gives. Now, my question is this. Do the instructions go into the jury? Does a written copy of the instructions go in?
They can. We're actually encouraging judges to do that. We're trying to use technology in an effective way. We've now put 463 model criminal jury charges on our internet that judges and practicing attorneys and the public can get a look at. With a button, you can assemble a jury charge. It has all of our eyewitness identification charges. So a judge, and I did this, can assemble a jury charge in 15 minutes.
Wow.
And then personalize it to the case. One of my first assignments as a new prosecutor was pulling this together. It took me days. You can now do it in a matter of minutes, and the charge is then ready to print out and give to the jurors, which I think helps.
Right, it does, because as a judge, and it takes me days to write a charge,
Come to New Jersey.
I should come to New Jersey. But I will tell you that, I read these pages of charges to the jury, and I don't know how many of you have been on a jury, and I wonder how much is really being absorbed by the jurors.
Right.
And that's why I ask whether it goes in.
Right.
So I want to take an opportunity to ask. I have many audience questions. We only really have time for 2 or 3. But 2 different people asked forms of the same question, and I'm honestly not sure whether it's for Justice Kornreich or for Justice Rabner. But they're basically asking, if eyewitness identification is so complicated with so many factors, why not conduct eyewitness identification in front of a jury?
Well, you can answer, but...
Well, for starters, remember the purpose of the identification. It's often to identify the suspect. You're not going to get to the jury if you don't solve the crime. So at a very basic level, police officers are attempting to figure out if they have enough evidence to go forward with the case. Your Fuller example. The investigating officer at the outset said, we don't have enough here, we should close the file. You can't make an assessment about whether you have enough until you go through the procedure. And then by the time it's done in front of the jury, you, of course, have had these prior identifications which may or may not have been suggestive. So it's an essential building block to figuring out whether charges can be brought and somebody can be accused.
It's an investigatory tool, and it's really the police who conduct that. And it takes a long time to go to trial. And, and a lot of things happen, including in court, before you get to the trial stage. And so, frankly, even if you were going to do it in front of a jury, and you do it in front of a jury in the sense that the prosecutor always asks, do you see the person who attacked you in this courtroom? And inevitably they point to the only person sitting at the defense table. But so there is a bit of an ID right there. But it's going to be a long while between the crime and the ID if you wait till trial, beyond the fact that you need it to find the person.
So it actually serves justice better to do it earlier in the process. Maybe.
Well, I don't know if justice in a loose term, yes.
Okay. Another question, because Justice Rabner, you alluded to it but didn't expand on it, which is the role of hypnosis in recovering witness identification testimony, things like that. Would either of you care to comment on your own judicial feelings, as opposed to personal feelings, about the usefulness of hypnosis?
The case that I alluded to, the 25-year-old rule that permitted hypnotically refreshed testimony after we sent it back and examined the science and examined better evidence. It was good science, not junk science. The doctrine was reversed. It's no longer allowed in New Jersey.
Okay.
And a lot of the times that came up was not only in criminal cases. We've had cases like that in the civil side, on the civil side where a daughter, perhaps, will bring an action against her father after hypnotic recall, and the case will deal with the father having sexually abused her when she was a child, and she's totally forgotten it until she's gone into.
That was actually part 2 of the question, so you're right on case.
I don't think it's accepted science. I don't.
Right. The last one, clearly, I think, for Justice Rabner, which is since Henderson, Have there been any statistical studies done to see if there are fewer convictions on eyewitness cases, or whether because of the changed police conduct, more suspects are set free because they were not identified, pretrial ID procedures, etc.?
Two pieces to the answer. First, it's too early to tell. The Henderson ruling applies prospectively. And it went into effect last September 1 at the time the new jury charges were fully vetted and ready to go. So we're just months into it. It's something we'd like to try to figure out how to test, and it's very hard to test because there's no baseline for what should have led to a conviction or an acquittal before. There's no panacea case that we can compare it against. So that's one piece, but hopefully in 5 years or so we'll be able to make a broad-based assessment as to the conviction rate and see if it ties back to Henderson. The other piece, though, is that it's not just convictions that are the question. It's the effect that it has on police conduct during the course of an investigation, deterrence. Officers now know in New Jersey that if they don't do the lineup in the way that the guidelines require, their own guidelines, which the court has endorsed in large measure, they're going to hear this charge, which highlights for the jury the potential unreliability of the evidence that they've presented. Police officers don't want to have that charge. So our hope is that they will conform their conduct to the best practices that are not suggestive, and we won't see some of those cases brought into the system altogether because the opinion lays clear what the consequence is if the approach the science recommends is not followed.
Thank you. I am a rabbi. I did not write one of those letters. But I do, on behalf of all of us here, want to thank both of you for an incredibly fascinating and illuminating talk. Thank you.